If you're wondering how long probate takes in Missouri, you're not alone. It's one of the most common questions that we hear. Today, we're going to break down exactly what to expect from start to finish as far as timelines go in the state of Missouri when it comes to probate. I'm Dan Schnur Busch. I'm a probate attorney here in Missouri, and I'll help you understand the timeline to expect in probate cases in Missouri. So, put simply, probate is the legal process of settling someone's estate after they pass away. Now, in a full probate administration, this typically takes from 6 to 12 months, even for pretty simple cases. At a minimum, it's going to take about 8 months. In complex cases or where there's disputes or other problems associated with the case or complexities such as small businesses that need to be sold or administered, it can make the process take even longer. Now, basically the way it works is this. In Missouri, when somebody dies, technically, their property passes to them, their descendants, or to their heirs as a matter of law automatically. Now, it is subject to the control of the personal representative for the purpose of paying debts and creditors. So really, the probate process is primarily about protecting creditors and about ensuring that a will, if there is one, is respected. Now, what that means in practice is that in order to go through probate, in order to get property into your name, however, in many cases, you're going to need to go through probate anyway, because title companies, if you're dealing with real estate, banks, and other brokerages, they're just not going to talk to you unless they have some sort of verification as to who the heirs are and who's in control of the property, and that person is usually the personal representative. Now, the timeline, it can be broken down kind of like this. In the first couple of weeks after retaining a law firm, and in most cases, you are going to have to retain a law firm. When the first couple of weeks, you're going to be, the law firm is going to be obtaining information from you in order to properly fill out the appropriate application paperwork to get that filed. Once that is filed with the court, you're going to be waiting on the judge. Generally, this is going to be an additional several weeks to a couple of months, depending on which county you are, for the judge and the clerks to review your application and to rule on it. Oftentimes, there will be some kind of response or a checklist or what's sometimes called a deficiency notice, where the court is basically saying to the attorney or to the filing party, hey, we need a couple more things. Please give us this information. Okay, this process usually takes a couple of months because we got to wait for the court, and it depends on which county it is. Some counties are very fast. Some counties will get right back to you very quickly. If you go to somewhere like St. Louis County, you're going to be waiting 6 to 8 weeks in most cases for that process to complete, just to become appointed as the representative. Okay. Now after that, once you're appointed, there's going to be a publication in the newspaper that says, hey, this so-and-so has been appointed over the estate. And once that happens, Missouri law at section 473-360 sets a 6-month time limit for creditors to come and file a claim, right? So if there are creditors out there, they have 6 months, in most cases, 6 months from the date that that notice is published in the newspaper to come and file a claim. Now, there are exceptions to this, important ones. The government, state or federal, Medicaid, the state agency that pays for health bills for the indigent and elderly, they're not subject to the 1 year or the 6-month filing limit. The IRS, the Department of Revenue in the state of Missouri, not subject to the 6-month filing limit. They can come along, as long as the estate has been opened, they can come along and file that claim at any time. Now, there are methods that we use to kind of cut them off, where we file certain forms with the IRS, with the Missouri state agencies. Basically, it's a form that says, hey, please give us a final indication of what you think we owe. Otherwise, just let us go. Okay. In addition, during that, the first 30 days after appointment, there is the representative is responsible for compiling an inventory of assets that the deceased person owns. So this is stuff that is left in their name, that has no joint owner, has no beneficiary, not in a trust. It's subject to probate. Okay, so that's what those first 30 days after appointment are for. So by this point, we're already about 3 months into the probate process. Okay, and remember, after that's done, we've got 5 months left to wait until that creditor period expires, a 6 month total, 6 months and 10 days in most cases. So during that inventory period, you're going to be taking time to identify what those assets are, figuring out what they're worth, putting them on an inventory, getting it notarized, and then we're going to get that filed with the court, okay? So that kind of tells the world, all right, here's what the estate is worth. If you have a creditor claim, here's the pot of money that we're fighting over. You can't go outside of the estate in most cases. You're just looking at what's in the estate in many cases. Now, during that 6-month period, part of the job of the representative is to figure out which creditor claims, if any get filed, are valid. Now, it's important to note that if a creditor claim is not filed in probate, generally speaking, that means they're not entitled to be paid in the state of Missouri. They have to be filed in probate. So if somebody sends you a letter that says, hey, your deceased loved one had a credit card bill for $6,000, please pay it. You don't have to pay that. The estate has to pay that. And there are rules that they have to follow to go through in order to get paid in probate. And one of those rules is, got to hire an attorney in most cases. Got to file a creditor claim in a full and open probate estate. Small estates don't count. Determination of heirship cases don't count. Refusal letters don't count. Those are short form types of probate. And we'll talk about those in a minute. It has to be a full and open probate estate that we're filing a creditor claim into in order for it to be valid. So most creditor claims are not valid. They're not properly filed and don't need to be paid. Okay, that's a surprise for a lot of people. But if any are validly claimed, and they've gone through the trial to prove up the validity of their claim, and the judge says, bang, gavel, you've got to pay this creditor claim, then one of the jobs of the representative is to make sure that it is paid during that 6-month administration period. It can be paid afterward as well, but generally for time's sake and efficiency's sake, we want to try to get all that taken care of within that 6 months or very shortly thereafter, okay? If assets need to be sold, should be sold during the 6-month period, right? If there's real estate that needs to be sold, get a realtor. If it's a supervised estate where the judge is supervising it and it's not an independent administration or an unsupervised administration, then we're going to need to go to court and get an order that says you're allowed to sell the real estate. So you're going to be selling assets during this period. This is that 6-month window after publication. So throughout that, will be months 3 through 8 or 9, okay, when we're generally going to be dealing with all those issues. If there's personal property that needs to be sold, like auctioning off or going to an estate liquidator company to help you sell off the stuff in your deceased loved one's house or apartment, this is going to be the time period where you're going to be doing that. You're going to be dealing with final tax returns during this period. So filing the deceased loved one's final taxes. If the estate has generated income, there may need to be a separate tax return for the estate, independently of the deceased person. So they have an individual tax return, and then they also have, there may be an estate return if the estate itself has generated too much income during that taxable year that doesn't get paid out within the tax year. So it depends on kind of the tax year and when things fall. Once we get to the end of that 6-month and 10-day period, it is time to close the estate. Okay, so we got to compile everything in an independent estate where everybody's kind of waiving and consenting to everything. Generally, we don't need a lot of documentation to close. We just get signatures from everybody, and then we file the closing, and generally, discharge occurs shortly thereafter, okay? Statutorily, the discharge technically takes place six months later. In a supervised estate, we got to do a lot of documentation in most cases. We got to get bank statements. We got to get canceled checks. We got to get everything that every transaction in or out of the estate needs to be documented and proven to the court what happened with the money, unless the heirs sign off on it or waive it. But in a supervised estate, that doesn't generally happen, because if they had agreed to sign off on stuff, you probably wouldn't be supervised. You'd probably be in an independent estate, and they would have waived the complexity and cost and irritation of a supervised estate. But supervised closing generally takes longer. So we try to start that earlier, collecting all the documentation and getting everything ready to go, okay? Once that's approved by the judge, in many cases, there's going to have to be a hearing in a supervised estate, not in any other kind of estate. We'll be able to then distribute and liquidate that estate, pay everything out to the heirs or beneficiaries, and then probate is done, okay? Now, there's a lot of factors that affect how long probate takes, okay? The size of the estate matters. It matters how many pieces of property there are that you got to deal with, because it can slow things down if you have, 30 pieces of property and assets and real estate and brokerage accounts and all this other stuff, relative to, we get a lot of cases where it's just, nope, mom's house needs to go through probate. That's it, okay? A lot easier to deal with a small estate than a large one. But there is still that minimum time, but the more stuff there is, the more likely it is to start spilling out over the minimum time. If there are disputes, fights among heirs or the personal rep and heirs and beneficiaries over what's going on, who's appointed, oh, you stole money out of this account, yada. If there's any of that stuff, obviously that's going to slow things down and drive up costs. If there's a court backlog, that'll also slow things down. Like if you're in St. Louis County, especially, much slower. St. Louis City is a little bit slower. St. Charles is doing pretty well. Jackson County generally does pretty well, but they tend to be a little bit slower. That's on the other side of the state in Kansas City. More rural counties or smaller counties with lower populations tend to actually be a little bit faster. They tend to be able to process things a little bit more quickly. If there are missing heirs that we have to track down and we have to run background searches or hire a private investigator to find them, obviously that slows things down as well. The other thing can be tax issues. If there are if we have income for 1 year and we need to file a tax return the following year, or the way that things line up, it can end up dragging out the closing of the estate as well. So a couple different options for speeding up this process. If the estate is under $40,000, in many cases it can qualify for a small estate treatment, and small estates are much faster. Now, a lot of times they're still looking at 6 to 8 weeks processing time, because oftentimes that's how long it takes just to get the court to look at your application. But you don't have to go through that whole 6-month waiting period, right? Once the judge has looked at it, if they approve it, bang the gavel, give you the certificate of clerk, you're done. Probate's over. You can take that to the account or file it in the recorder of deeds office if it's real estate. Whatever it is, if the assets are under $40,000, the net value of the assets, so whatever the total value is minus any liens or mortgages or whatever, if the total net value is less than $40,000, you can, in many cases, apply for small estate treatment, as long as you who are applying are an actual heir and beneficiary of the estate. You can't be like an unrelated relative or something like that. If you keep good records, like keeping track of all the bank statements that come in a supervised estate, these things can make it a lot faster for you to process, because you can get everything to us a lot faster, or your probate firm or whoever you're working with. Working with an experienced attorney or someone who specializes in probate can make a dramatic difference, because the processes and procedures that are employed by somebody who does this all the time are radically different than somebody who dabbles in probate. For example, we've built out a tremendous library of automations and software advancements that make our probate process extremely efficient. Things are going out automatically by software queues and automated sequences that are unique to our firm. Like nobody else is building these in the way that we are, right? So if you're working with a firm that doesn't do it very often, or an attorney who doesn't deal with probate very often, we've taken over cases that were 3 years old, and somebody calls us and they say, oh, I haven't heard from my attorney in 6 months. I don't know what's going on. There's just a lot of people out there that don't specialize in it, and those things can really, really drag out the time in probate. Interestingly, something that we have found is that in many cases, the delays in probate are often the fault of counsel. Aside from the judge, they're actually often the fault of attorneys, and attorneys having poor processes and procedures and systems, and very rarely is it the fault of clients. Sometimes it is a fault of clients. There are clients who just don't respond to stuff, but a lot of times delays are actually due to attorneys. So having somebody who is experienced and who has the processes and systems built in place can make a huge difference in how quickly you get through probate, okay? Again, another major variable is how quickly the court gets back to you. That does have a significant delay depending on which county you're in. Could be St. Louis County, somewhere else, you might get done in a couple weeks. Like we've seen small estate applications where we file them in a more rural county, and we'll get the certificate of clerk approval from the clerk and judge in 48 hours. That's happened before. So it really just depends on who you're working with and how busy they are and what's going on. So that's kind of the key set of timelines. We've got that opening period, usually takes 6 to 8 weeks, depending on the county, could be less. We've got that inventory period for the next 30 days. We've got that 6-month creditor window that we have to wait to expire. And at the end of that creditor window is when we can start filing for closing. Okay, so at a minimum in Missouri, in a full probate case, you're looking at least probably 8 or 9 months. Could be much longer, generally looking at a minimum of about 8 or 9 months. Okay, so I encourage you to work with a qualified attorney, somebody who specializes in probate if you're dealing with a probate issue. I encourage you not to go to your family friend attorney or something like that who does personal injury or some other random area, just as you would go to a cancer doctor if you had cancer, and not your general practice attorney. I encourage you to work with a probate attorney and a probate firm if you're dealing with probate issues. It can be very complicated. Okay. Check out some of our other videos if you enjoyed this content. There's lots and lots of stuff that we talk about in the probate world. Thank you for watching. See you next time, guys.